Hello friends. Today we'll be talking about types of mediation. So mediation is an effective alternative to a court battle when parties involved in the serious conflict wish to find a resolution outside the legal system. Mediation involves the assistance of a trained mediator who facilitates the negotiation process between the parties, helping them find a common ground and reach a mutually satisfactory agreement. So, as we have already discussed in our previous classes, that mediation is an alternative to the court battle, it is an alternative to the court process in which there is a third party who's involved. That third party is a neutral person who is a mediator, and he facilitates the negotiation process for the parties and helps them to arrive at a win-win solution for both the parties. While there are general principles and techniques that mediators employ, the specific approach can vary depending on the type of conflict and the needs of the parties. So, there are some general do's and don'ts for the mediator, but the mediator can apply some specific techniques conferring to the facts and circumstances of the case. As per the needs of the parties, as per the facts and circumstances, the specific tactic of the mediator might vary. So, when we talk about the types of mediation, it includes facilitative mediation, evaluative mediation, court mandated mediation, transformative mediation, med-arb, arb-med, e-mediation, pre-litigation mediation, post-litigation mediation, and private mediation. Now, we will be dealing with each of them separately. So, first comes facilitative mediation. Facilitative mediation is generally considered as the traditional type of mediation. In facilitative mediation, the professional mediator takes on the role of a neutral third party who facilitates the negotiation process between the conflicting parties. The primary focus of the mediator is to assist the parties in finding their own voluntary and mutually acceptable resolution. So, facilitative mediation is one of the traditional types of mediation in which there's a neutral third party, that is the mediator, who aims to facilitate, as the name suggests, facilitative mediation. The aim is to facilitate the negotiation process between the conflicting parties to reach a mutually agreeable solution. Mediators tend to not vocalize their own views regarding the conflict and do not give their opinions as to right or wrong, but will make suggestions by resolution for resolution. So in this type of mediation, the mediator, he does not vocalize about his views. Rather, he will just make suggestions for the resolution. By keeping their views hidden and remaining neutral, the mediator allows the party to take ownership of the decision making. This promotes autonomy and encourages the parties to craft a solution that reflects their unique needs and priorities. So, the main motive of staying silent and not vocalizing his own opinion is that the parties can take autonomy on the decision making. The parties will feel that they are entitled to the decision making process. Next is evaluative mediation. In direct contrast to facilitative mediation, an evaluative or directive mediator will make recommendations, suggestions, and express his or her opinion about the strength and weakness of each party's position based on the law and facts. So, as opposed to what happens in facilitative mediation, in evaluative mediation, the mediator will give his suggestions, he'll make recommendations, and he will express his or her opinion as to what are the weaknesses in the case as per the facts and circumstances. He will let the parties know what are the weaknesses in the case which relate to law and as per the facts. Instead of focusing primarily on the underlying goals and interests of the parties, evaluative mediators direct settlement by evaluating openly to the parties the legal merits of the dispute and expressing his or her opinion. So, in evaluative mediation, the mediator's aim is to direct settlement. How? By evaluating openly to the parties that what are the legal merits of the dispute, and he will lay down that when the case goes to the court, then what would happen? What are the legal merits? What are the weaknesses? That would be laid down by the mediator. Court mandated mediation. In court mandated mediation, it is as a general rule, we all know that mediation is a voluntary process, but it can be mandated by the court. As the name suggests, it is a court mandated mediation. The mediation is typically defined as a completely voluntary process. It can be mandated by a court that is interested in promoting speedy and cost efficient settlement. When mediation is court mandated, it means that the judge orders the parties to attempt mediation as a way to encourage settlement and avoid lengthy court battles. The court may see mediation as a valuable tool to promote speedy and cost effective resolution. So, as I've already explained, in court mandated mediation, the court, that is the judge, he or she may himself order the parties to attempt to go for mediation. The main aim is to promote speedy justice and to avoid lengthy court battles. When parties and their attorneys are reluctant to engage in mediation, their odds of settling through court mandated mediation are low, as they may be just going through the motions. But when parties on both sides see benefits of engaging in the process, settlement rates are higher. So, if the parties are not willing to go for mediation, then in case of court mandated mediations, the settlement rates are much lower. Whereas if the parties start seeing benefit in the process, then the rate of success for the mediation process increases. Transformative mediation. In transformative mediation, the mediator focuses on empowering disputants to resolve their conflict while encouraging them to recognize each other's needs, goals, and interests similar to facilitative mediation. The process aims to transform the parties' relationship by helping them develop and acquire skills they need to make constructive change and be able to communicate and cooperate with one another more effectively. So, transformative mediation is more like facilitative mediation, in which the mediator's focus is to empower the disputants. And the main aim of the mediation is to transform the relationship between the parties. So, even if they are not able to reach a mutually amicable solution, at least the aim is to transform their relationship so that they are not in a position of conflict with each other. It is most helpful to parents involved in custody and parenting disputes, employment disputes, and other disputes wherein the parties need to maintain some type of ongoing relationship. The mediator is less concerned with whether the participants reach an agreement and more focused on helping them transform their relationship. So, where the relationship between the parties has to be an ongoing one. That is, they'll be in a relationship, whether it's an employment relationship or parent and child relationship. Such type of relationships which have an ongoing nature attached to it. These type of relationships are more benefited by using transformative mediation. Next is Med-Arb. Med-Arb is a combination of mediation and arbitration. So in Med-Arb, a mediation arbitration hybrid, the parties first reach an agreement on the terms of the process itself. Unlike in most mediations, they typically agree in writing that the outcome of the process will be binding. Next, they attempt to negotiate a resolution to their dispute with the help of a mediator. So, MEDARB, as the name suggests, it's a combination of mediation and arbitration. Here, in this process, firstly, the parties themselves, they agree in writing that the outcome of this process would be binding. Then they go for mediation. If the mediation ends in an impasse or if issues remain unresolved, the process isn't over. At this point, the parties can move to arbitration. The mediator can assume the role of arbitrator if he or she is qualified to do so and render a binding decision quickly based on judgments, either on the case as a whole or on unresolved issues. Alternatively, an arbitrator can take over the case after consulting with the mediator. So, if the mediation process is not fruitful and the outcome is not met, in that case the mediation process can come to an end, and then the mediator himself can play the role of an arbitrator if he is fit to do so, or an independent arbitrator can take over the case, and then the case would be decided on a whole or on the undecided matters. Next is ArbMed. This is a combination of arbitration and mediation. In ArbMed, another among the type of mediation, a trained neutral third party hears disputants' evidence and testimony in an arbitration, writes an award but keeps it to himself, attempts to mediate the parties' dispute, and unseals and issues the previously determined binding award if the parties fail to reach at an agreement. So in ArbMed, first there comes the arbitration process. The arbitrator will listen to the testimony and will evaluate the evidence and will decide for an award. But this award would not be disclosed to the parties. The attempt is made to mediate, and then he unseals and tells the parties as to what he previously determined or what the award was if the parties fail to reach at an agreement via mediation. The process removes the concern in MedArb about the misuse of confidential information but keeps the pressure on the parties to reach an agreement. Notably, however, the arbitrator mediator cannot change her previous award based on new insights gained during the mediation. So, one of the concerns that the MEDAR process deals with is that the confidential information that parties reveal while the mediation is in process would be misused if the parties go for arbitration. So, removes that concern because the arbitrator himself would decide the binding award earlier itself. But if during the mediation process, after the arbitrator fixes an award and does not reveal it to the parties at that time, when the parties go for mediation and some new insights are discovered in the case, then the arbitrator is unable to make changes in what he had decided earlier. E-mediation. E-mediation in e-mediation, a mediator provides mediation services to the parties who are located at a distance from one another or whose conflict is so strong that they can't stand to be in the same room. So, e-mediation, or in other words, online mediation process. In this process, technology has played a very important role, and it is particularly helpful when the parties are at a distance from each other or when they cannot even stay in the same room. E-mediation can be completely automated online dispute resolution system with no interaction from a third party at all. But e-mediation is more likely to resemble to traditional facilitative mediation delivered at a distance. So e-mediation, the concept is similar to facilitative mediation only, the difference being that it is in online mode. That is all for today. Next other types of mediations will be discussed in the future videos. Thank you. I hope you enjoyed the class.